Welcome, everyone. This is David McNichol, and it's just 12 o'clock noon right now. I think we'll wait a couple minutes just to get a few more of the people attending, and then we'll get going. Well, welcome, everyone. This is David McNichol, and we're going to get going. Looks like Ian might have just stepped away. Oh, there he's back. Hi, Ian. So this is great. Happy to get everybody together during the middle of the summer, but I think we've got a very interesting topic here. Certainly, it's something that comes up with a number of our clients and their relatives, and so we're very pleased to say we've got an excellent guest here, and Ian Hull. I'll present him in a moment, but the main subject will be about real estate, cottages in specific, and how you can plan for them and solve them with hopefully as little problem as possible amongst family members, and especially with CRA. Next slide. Just a disclaimer that we're not providing any type of advice here at all today. If you want personal advice and direct advice, then reach out to us directly. Ian and his office would be happy to speak to you as we would about your investment needs. Next slide. Yeah, so that's me on the left. I'm really just going to be introducing Ian today and joining in on the Q&A at the end, but I'd like to just do a brief introduction on Ian Hull. Ian's been a great friend going back to high school days at North Toronto Collegiate Institute and at the University of Western. We're actually fraternity brothers there as well. And Ian's been practicing law since 1990 when he started with an excellent firm in Koski Minsky. And then he made a wise decision and partnered up with his father, Rodney Hull, who I knew very well in his time. And Rodney was a very established and capable lawyer who built, and Ian's really grown it to be Canada's most successful estate and trust law firm. And they also do capacity litigation as well. So Ian and his team are experts in the area of estate planning. And I'm really just going to pass it over to you, Ian, to go through your slides and try to pique some curiosity for everybody on the call. And for those who are on the call, know that this will be recorded. So if you have to duck out early, you will get a link to this later on so you can pick up where you left off and or share it with any other friends and family that this might be of value to. So Ken, next slide, and over to you, Ian.
Terrific. Thanks, Dave. Real thrilled to be here and honored to chat with everyone. We're going to leave lots of time for questions as well. We've already got some pre-questions, but I want people to know that that's highly encouraged. So what I want to talk about today is the vacation property. Obviously, I'm actually speaking from my cottage this week. I have my mother stays up at our cottage all summer, and have the privilege of she's 89 and enjoys the cottage very much. And I have her up here for the summer, and I'm working from the cottage this week, which is one of the bonuses of COVID. This is my cottage. I have 3 kids, and of course that's going to bring with it some of the issues that are swirling in my mind as we present today, but is a real sort of concern in terms of all of our estate plans if we have recreational properties. I'll just start off by saying, and we can just go to the next slide, the discussion with your children is an important one. I would say in my practice, and I've been practicing law for over 30 years, the 2 areas of highest friction are second marriages, second relationships, which is we're not going to talk about today in terms of estate planning and making sure that we factor in as much as we can to manage that issue. But one of the highest areas of friction is, of course, the passing on of a treasured asset. And that is often a cottage, for example, and so I don't want to underestimate the importance of considering this and discussing this with your heirs as soon as possible and in a fulsome way, because that in and of itself can help tease out some of the issues that I'm going to cover off today in terms of options. And I don't use the word solutions because solutions is kind of overstating it in the sense that each individual family have their own ways of dealing with things. When I was discussing this with some friends the other day that I was going to be presenting this, one of my friends whose family passed on the cottage successfully was singing the praises of the option of passing the cottage on to all the children equally in the form of a trust. So the first 5 years after death, you create a trust, sufficient funds in the trust that allows the kids to get their sea legs and determine who actually wants to be part of the cottage, who doesn't, who wants a buyout, and so on. And that's just an illustration of a scenario. It's an option and a solution in that family. It's also an illustration of the importance of the discussion. He said to me, and it's true, and I recommend this as much as we can, he said to me, the kids talked about it before. And we all loved the cottage, but we all recognized that things could change, and we were all at a different time in life. So the opportunity to bring the discussion up and brainstorm solutions is really important, because in the right circumstances, you're going to be able to tease out some of the options that are going to be more palatable to the family. And if the idea is to pass on a special asset like this in this way, then the discussions are important. Of course, when we're passing on farm properties and things like that, very different considerations. These are typically, obviously, recreational. And, the old adage where a farm property used to be passed on to the eldest son, that's sort of using a sledgehammer in estate planning in today's world. Well, the same is here. If we haven't had an opportunity to discuss with our children some of the options that they might want some input in, it can be a bit of a sledgehammer estate planning move. So that's just my starting point. And, there's lots of solutions or options in terms of trying to discuss with your heirs, but some of it can be best done in an informal way to at least tease out the reactions of the kids. All right, the next topic I want to talk about, the next slide, is and this is for sure, David gave a great disclaimer at the outset. This is very important that I am not a tax lawyer. I have managed to go through my whole career just understanding concepts of tax, not tax law itself. But the simplest and most profound aspect of a recreational property that causes its problems is, of course, the capital gains. And you're looking at 25 cents on the dollar of the gain, typically if you've held a cottage property for many years, because your cost bases are not reflective of the current market. And certainly some of us, even myself, who I'm 60 years old, I bought our cottage in 2006, and of course it has grown in value, but I grew up with a cottage that was in Lake of Bays that my parents paid $12,000 for. Of course, when they sold it, it was worth significantly more than that in the mid-thousands. But the point is this: anticipate the capital gains. Look for that 25 cent dollar that's going to need to be funded, typically within the first 18 months of your death, and look at ways to pass on the capital gains exemption to the surviving spouse, or that's the most typical way to defer the capital gains. So the only other aspect of it is that, and something that I learned painfully is that people aren't as careful as they should be. Keep your receipts. Document you want to get your cost base up as high as possible. And so when you replace the new deck, keep the receipts. And if you're replacing the roof and so on, capital expenditures like that can all drill down on your ultimate costs, enhance your costs, and ultimately drill down on your tax burden. So that's really the starting point anyway. If we can have a good discussion with our family and then use some foresight into anticipating the capital gains tax. And I know through David's office with some of my clients who work with him as well, that your office, David, of course, has had this direct discussion with your clients to anticipate it so that they can free up money relatively quickly. Now, 18 months doesn't sound that quick, but in the terms of administering an estate, coming up with what could be a significant amount of tax at that point in time is vital to use the tools. And the next slide just talks about one of the classic tools in managing this is the use of life insurance. Of course, that's just a deferred tool that it's a pretty straightforward opportunity, but of course your investment portfolio can serve as the same source of bringing a solution to that. All right, so let's go to the next slide. In terms of managing the taxes during lifetime, another way of associating this is, of course, to consider transferring the property earlier on in your life before you pass, and it allows some of the tax issues to be managed as well. But again, today isn't going to be about the taxes. There are tax options available. Trusts can be arranged, as I say, on death. And that, my illustration earlier was a testamentary trust. It was created on death. It wasn't created during lifetime, but there's obviously opportunities to put assets like this into trust during your lifetime as well. All right, so another option, and it comes to the managing of this transfer in the next slide, is the option of gifting. So that, of course, will trigger your capital gain. So the option brings with it good and bad. We all like to defer tax, but in respect of recreational properties, the tax is not going to go away. And certainly with COVID, governments are going to be looking to opportunities to tax more and not less. So if the reality is that you're going to be looking at the passing the property on during lifetime or certainly immediately after death, and it may make sense to pass it on prior to death. The only concept I like to add, part of that solution is I suggest is that you talk to a good lawyer who will do a deed of gift in respect of the contents, just to make sure that we've covered off. Sometimes that can bring it with its own fight. And then, of course, a proper transfer. A deed itself through real estate counsel is an important option and one that needs to be done properly. The next slide, obviously the sale. Family chose to, we have 5 kids, and we all agreed it was best just to sell the property prior to death. That seems like sort of an obvious comment, but I can tell you it's more and more becoming an estate planning tool of choice with a lot of families who do not want to race into a contentious and possibly uncontrollable situation with the family either during your lifetime if you're talking about gifting and or on death. So these are all options that you want to consider, and of course you can you're going to trigger the capital gains, but you can consider selling the property with a mortgage bank or those kinds of tools as well. The next slide is the option of an inter vivos trust. So putting the cottage into trust. This tool, this estate planning tool, was fairly popular in the 60s and 70s, and maybe even later. You don't see it as often now, but it's an option to put the property into a trust during lifetime. Now, you'll trigger the gain in the process of passing the trust into the into your inter vivos trust at the time of the transfer. So whatever capital gains is owing will have to be paid then, and you're able to defer some of the tax, obviously, while it sits in the trust over lifetime. But the good thing about trust is that it obviously helps protect from creditors, and it keeps the asset sort of separated from within the family fighting. And I'm going to talk about in a minute some of the options once it's in trust as well to consider. But the tool of putting it in an inter vivos trust is often used and is often helpful. The only twist I would say is, and I remind my clients, is that if you're going to do that, always consider the funding mechanism. As I said about my earlier illustration, when the trust was created, a testamentary trust on death for the transfer, the funding mechanism was included in it. So he put it into trust for 5 years, and he set aside sufficient funds to operate the cottage during those 5 years so that no one was at disadvantage or advantage. The same goes with the living trust. Too often these trusts are created, and at the same time, they're not picked up on the back end with some sort of funding mechanism, either yourself putting in some sort of lump sum, or the beneficiaries agree to funding it. But of course, the living trust itself creates a burden, a financial burden, that if you're giving up the asset and you're still paying for the ongoing running of it, you want to be ready for that. The living trust itself, as I say, is a tool that hasn't got the same tax advantages as it used to, but it does give some creditor protection. So the beneficiaries, if you're worried about your kids' financial circumstances, exposure there, or you might have some of your kids are professionals that you'd like to protect the asset from them. It's a tool that is useful and can be helpful in the right circumstances. All right, the next option is we're going to talk about is, of course, transfers on death. The tax issues are here again. describe them. There's lots of options available on transfers on death. And we're going to talk about a few of them just to give you the sort of the lay of the land. The option of the next slide, please, is joint tenancy. Now, this is one that is often used to allow for smooth transition. The problem with joint tenancy, so I don't want to be too legalistic about this, but let's talk about what this concept means. If you own the property, and many of us own our houses jointly with our spouses, for example, so then on our death, it automatically passes to our spouse. And in current tax circumstances, if you own it jointly and it passes to your spouse, there's no tax either, because it's your principal residence typically, and it passes to your spouse. Well, a cottage, of course, brings with it no personal residence exemptions. But if you're as between spouses transferring, and a joint tenancy makes a lot of sense because you're still going to pass it on to your surviving spouse. It goes smoothly to your surviving spouse, and it does so without a tax consequence. So again, there's pros and cons, of course. There's issues of creditor proofing because it leaves the asset exposed, but there's also issues where we add in our child. So say we have a situation where we want to put our children on as joint tenants as well. Well, it comes back to all of these options that we've talked about, and that is that be ready to lose some control. You are going to lose control, obviously, if you put it into an inter vivos or a living trust. You're going to lose control, obviously, on your death, because that's what you want to do. And you're going to lose control of the asset on a joint tenancy arrangement. And an easy illustration is this. The child gets added as a joint tenant. You still create the potential for a tax event on your death because you've added in a non-spouse to the joint tenancy. So you got 3 people owning it. That non-spouse, you create a potential tax event because it's going to a spouse and a non-spouse. So the rollover, you need to get advice as to whether or not the rollover will work. But more importantly is you have given the power of that child to, without notice to you, sever the joint tenancy. So if I own the cottage with my son, he could sever the joint tenancy and take essentially 1/2 interest before I die without notice to me. Now, again, it's a bit of a chicken little scenario. It doesn't happen a lot if we've got trusting families. All it does is that, unfortunately, I litigate over these things. It just illustrates the kind of control you have lost by putting it into joint tenancy. So that the good comes with the bad. And that's the problem with all estate planners, is that it doesn't work for everyone, but more importantly, there are exposure to any of the tools that you use. So the joint tenancy is got some downsides, it's got some upsides, and so forth. So gifts by will, the next slide, thanks. This is what I've described already, and that is where the conventionally it'll go. You could give it outright to one child over the other. You obviously sort of more or less covered off thinking that you want to consider in gifts under a will. Some of the creative planning tools, i.e. the idea of a lifetime, a 5-year trust, those kinds of things are all available. But gift by will is I would say, the conventional approach. Now, within the will, the next slide talks about outright gifts. So there's 2 ways you can give something away under a will. And it doesn't get any more complicated than this in any estate, is you give it outright or you give it with strings attached. All right, so outright gift, I give my cottage to my 3 kids outright, and knock yourselves out, you figure out what happens after that. That's an outright vested gift at the moment of your death, or the last to die, depending if you've got a situation with your ownership between spouses. The next slide talks about testamentary trusts. So that's the second way you can give away anything under Ontario law, and that is with strings attached. So there's a trust within your will. That's a testamentary trust. And that's the scenario that I've already described in terms of making sure that you will create some sort of prevailing terms over the cottage. And I say that because my illustration was a 5-year term, but lots of times people will say, I put the cottage into trust in the testamentary way on my death, and to be shared as between my 5 children and their grandchildren. There's some restrictions. Trusts in Ontario don't last forever. Every 21 years, you're going to have to pay tax on that no matter what. But you've at least created a trust for ownership interest purposes for a 21-year period without tax, with some tax advantages. All right, next slide. This is what, and I'm just going to give you an overview of a process that we've had some success with. Agreements to use the property. Now, sometimes you will see these agreements created within a testamentary arrangement, i.e. in your will, or it's what I've seen it actually attached to wills as an agreement that parents have said, we wish you to follow this agreement, the ownership of the cottage. But typically it's arrangements where it's essentially a contract within the family to create a working arrangement for the use and upkeep of the cottage. And you can literally enter into this in a contractual fashion, so to speak, and binding on all of your children or all of the participants, including participants who are in-laws. Probably in the last 30 years, it's come out of favor, but you've also there's also been arrangements that were created which were essentially kind of corporate-like, where the individuals become a shareholder within a corporation and so on. That hasn't been used as a tool very often because it does get extremely complicated, and the rules for that are much more rigid. So let's just look at a situation where it is essentially a family partnership, and an agreement is created. All right. So the first term, not the first term, but a fundamental term is the next slide, and that is, of course, funding for maintenance, repairs, and improvements, setting up the maintenance fund, contributing terms, maintenance of the descriptions, i.e. capital improvements versus non-capital improvements, defining those, holding the funds in trust. Sometimes I see my clients who say, look, I'll put a couple $100,000 in at the beginning, that'll start the fund, but after that runs out, they've got to start funding it themselves. If you're anticipating, the cottage roof's going to have to get repaired within 5 years to your death or something like that, that can be a handy tool. But you're setting up a mechanism, and our contracts that we have on this are obviously flexible, and they are focused on the individual circumstances. Some people have a large erosion problem. I just did one with the Lake Ontario cottage where erosion was a big issue. And so huge costs come out of preventing erosion. And so we had a special erosion fund where we were, that we created. But it ties to the individual circumstances. But what I'm saying is that you can set out terms that really focus the expectations of the parties. The next term, the next slide, is we have in our contract is a decision-making term. How are decisions going to be made? On what basis? Is it going to be on a majority basis? Is it going to be on a unanimous basis? Are we going to appoint someone on an annual basis or a just did one, we appointed someone as the managing, we call them the managing partner, but the managing partner of the property for a 3-year term. And it's a revolving term. So there's 3 kids and you can't keep the job like running for president more than 2 terms. So the maximum someone can have control over that role is for 6 years, and it allows for obviously removal terms as well in case the managing partner becomes rogue or becomes unwell or becomes disabled and so forth. But a decision-making process that's described in the contract, and these are really co-ownership agreements, all right? At the end of the day, I always describe to my clients when they're getting into this sort of situation that you're running a co-op. And within that co-op, it is not uncommon to have obviously a sort of an executive committee, so to speak, but the ownership interests are equal and binding amongst each other. So that being said, the next term that's within the next slide, please, within the concept can also be an agreement, any sort of assignment of responsibilities. And this is again tied to the co-ownership agreement, and it can be setting up responsibilities for core elements of the upkeep. So for example, someone can be in charge of on a revolving term, or someone who has the expertise for landscaping. And they're responsible for that and reporting that kind of operation. The next slide, please. This is the one that, of course, is potentially most difficult. I live on a beautiful lake up in Halliburton where we have two relatively large developments, three actually, that are shared ownerships. I learned a lot from my friend John Puffer, who's established these throughout Ontario, but the ones at our lake, and I looked at his agreements as well. Shared ownership, one of the biggest points of friction, of course, is scheduling. And so scheduling the use of the property properly done in the form of a contract is useful. And there's an app out there. I forget the name of it right now. Sorry, I'm forgetting the name, but that one of my clients uses as well for scheduling, allowing for flexibility so that instead of saying you only get the first 2 weeks of July on a revolving basis, there's more flexibility to say, geez, you know what, one of my kids got sick with something, and so we'd like to change our week, and you can do it online in an efficient way. But scheduling is obviously an important term of any co-ownership or co-use agreement. Next, there's always got to be consequences, and basically consequences are default tied closely to the financial commitments that people are required to pay and fund. If there's one child that just can't keep up, there's terms that you can provide for some relief, and then allow for a certain point in time where there's a default and that the ownership interest gets bought out, and you create a fair market value established valuation process through an appraiser. Typically what you would do, sometimes it's 3 agents, or sometimes it's an AAIC qualified appraiser, depending on how you want to do it. And there's a triggering clause there. I want to leave enough time for questions, so let's go to the next slide. We also include a clause for, obviously, death. And in that situation, what we do is we make sure we've talked to the clients as to the co-owners beneficiaries. So can you, like a shareholder agreement is often the case, can you pass on the ownership interest to an in-law or not? And that's really the question you want to make sure we've talked through. Does the surviving spouse of the owner take on death? You can put in a clause that says they do not take in any event. It has to pass on to the lineal descendants. So only the children of the co-owner. And then again, at that point in time, evaluation has to be given to the possibility of being simply buying out the estate. But the big issue there is, of course, who is a potential subsequent shareholder in that sense. So who could possibly be, and is it just and who has to qualify for that? And is it a lineal blood relative, or is it an in-law that can qualify? And that's important to cover off. Of course, when you've got a joint ownership situation where you put something in joint tenancy, the surviving joint tenant may be eliminating the ownership interest of a beneficiary. So those you can see where there can be problems. So if you overlay the joint tenancy agreements with these kinds of contracts, it helps control the lineal descendants passing on of the cottage itself. Last few couple terms that I just want to cover off before we get into questions. Next slide is incapacity. So that can, of course, happen where an owner is incapacitated, and the terms of that need to be established, and what triggers it. Do we need to have a doctor's note, or is it sufficient to have finding incapacity? What's the triggering point? Can a power of attorney step in? If that power of attorney steps in, is that co-owner who is incapable prevented from using the cottage anymore? Do they lose their interests at all? The next clause we'd like to include in there, the next slide, is just the sale of the terms, the sale of the interest, and some of the common terms that we want to deal with in the last clause. And then that last slide just deals with involuntary dispositions, which is situations of bankruptcy and so forth. What happens to a co-owner who becomes bankrupt, and the impact on their transfer of ownership and their interests and their financial interests. So that is a sort of overview of some of the terms of a co-ownership agreement as well. So just in conclusion, I say this, if we can sit back and look at the asset, decide just how important it is, and if it is that important to pass it on, you can get into these kinds of what are relatively complex estate planning steps to consider the options. But one of the easiest options, of course, is to put it into the open market and let the children all enjoy the spoils of their death and let them go get their own places to create their own memories. But those are personal decisions for all of us to consider. And one that I know I personally struggle with. I don't know what my kids will do with our cottage, but it's something that we're going to start talking about more and more as they get older and as I get older. So, all right, Dave, I think that covers off essentially what I wanted to cover in terms of the content, and we've got some time and love to deal with some questions.
That's great, Ian. Good overview there. You got through those slides rapidly and covered a great deal of information. So let's try to get into some questions. We had a whole bunch come in over the last week. So I'm going to start from the top here. And, as always, if they ask too many tax questions and that, we can just defer and perhaps send them on to their tax accountants for answers. Here comes one. I'm wondering about homes that are owned outside of Canada, bracket in Europe, and the tax consequences on death. Well, here we go. That's the first one.
Well, ownership interest in Europe. So in short, I'll say this on the tax issues. Assets that are offshore, there's two big points. One is that on the estate planning standpoint, make sure you've created some sort of local estate plan. And that may include a will. It may include, for example, in Europe, you can transfer properties after death through a power of attorney. So there's all unique opportunities to do planning. So that's number one. Number two is the tax hits are significant. And so again, taking local advice on that is so important. Europe it's got planning problems in and of itself because there's certain parts of Europe have forced heirship. The U.S., after I think the minimum is 11 million, the transfer of the tax consequences post 11 million in value of your global estate assets can be draconian. So these are all things that are important to sit down with, not just your tax advisor, but someone like David to say, look, these are the kinds of tax hits I'm looking at, not just for the property. See, too often people look at tax from the standpoint of that isolated asset. What I tell my clients is make sure your tax advisor has gone through your global tax exposure, because you might be able to think, oh, I'll fund through this investment account the tax on the cottage and everything will be fine. But then you find out that you've got a global exposure that's 3 times that. Then you got to sit down with Dave and find out how we're going to fund this in an efficient way. So just be mindful of process, and that each jurisdiction brings with it its own unique processes. It is not a good idea to rely on Ontario planning with assets outside of Ontario. And that goes for provinces or obviously in Europe or the US. Get planning advice local.
Okay, that's great, Ian. Here's to be an easier one. How does sale of cottage work with probate and or joint tenancy?
So a cottage, probate itself is, there are planning ways. So the tax on a probate is 1.25% approximately. So we don't want to get too excited about it. It's an important number in the sense that if you can avoid it. There are planning tools available to help you avoid the probate tax of a cottage. It depends on the location of the cottage. But on balance, most of cottage country is stuck with the need to transfer it with a will. And if that's the case, you cannot avoid the probate tax. And I say that because most cottages are in land titles. In Toronto, it's a little different. But most cottages are in land titles outside of Toronto. So you're going to have to look to being ready to fund the tax, the probate tax, again, a modest amount. In a joint tenancy situation, it triggers the tax if it's not going to the surviving spouse. So again, you're looking at, it doesn't matter if I own my cottage here with my one son, for whatever reasons I've set that up, we're going to have to pay the tax at the point of the transfer on my death and the joint tenancy. There's also some competing concerns out there, and this is not tax advice, but something you need to ask your tax advisors. When you create the joint tenancy with a non-spouse, you may be triggering the capital gains at that point. Now, CRA has done a few IT bulletins on this, and I'm saying may because I'm not the tax expert, but again, something to look at. If you're giving up control, make sure you're not also triggering the tax. And that's easily identified through your tax advisor.
Here's another out-of-country question. I have rental condos in Hawaii joint with my wife, and as Canadian, when I pass away, is the capital gain fully taxable when we pass on in my estate?
Just, first of all, you need a lot more information. Expect a big tax hit, though. It's just a question of whether you can stay within the U.S.-Canada protocol, and I definitely want to talk that through with my advisor.
Okay. Here's another one. Can you provide more information on a joint partner trust and asset inheritance trust for a cottage? The owner is a surviving spouse with 6 adult children, and can this be transferred with no tax consequences? Can she still designate the cottage as her PRE? I guess that's principal residence at death. Thank you.
Yeah, lots of tax issues in there that I can't touch, but one of the things is people are doing more and more is, especially since COVID, they moved out of Toronto, they keep a small condo in Toronto or rental property, and then they designate their house, their cottage as the principal residence. Great plan, great idea. So to the extent that you can do that, that's got lots of good tax planning and good reasons for it. The joint partner trust is a tool. It's the same as, but it's similar to the alter ego trust. These are government sanctioned trusts that can be established during your lifetime after the age of 65. And they give an opportunity to help you with some probate tax planning, allowing, if properly done, there are certain circumstances where those sorts of trusts can help avoid some tax, some estate planning tax. Estate probate tax. Ultimately, you're not going to avoid the tax, except I guess if you can get your cottage to be your principal residence. And even that, I don't know how it works historically. If there's any, I think it's clean once you've held it principal residence for 2 or 3 years. But that again is not within my expertise. The key about your cottage is that there's going to be somewhere they're going to get something from you, and some eventually they're going to get some tax out of you. But the joint partner trust and the alter ego trust is an interesting tool that brings with it its own positives and negatives, and could be the purpose. It could be the source of a whole seminar for those who use that as a planning tool. But it is available and worth asking your lawyer about it, seeing if it makes sense in their circumstances.
Okay, this one's come in several times. What taxes will be paid by my son when he inherits my house?
Well, again, you have to know a lot more information, but the principal residence exemption would eliminate the tax if you designated it as your principal residence. And if it didn't, and it was a secondary residence, the tax, as I say, roughly is 25 cents on the gain. When I say the gain, is you just take what it costs you to get the property, throw in your adjusted costs, which are costs that were incurred properly for the purposes of getting your ACV or the adjusted cost base, and then you look at that and what you sold it for, and then you just take about, relatively speaking, about 25 cents on the dollar tax paid. So if the gain was $100, you're looking at a $100,000, you're looking at a $25,000 tax hit.
Okay, here's one. Tax treatment of sale of principal residence with subsequent move to summer cottage.
Yeah, this is something you really do want to chat with your accountant. I just only know anecdotally. I think it is 3 years you hold it. So if you sold your house and you move to the cottage and you start filing your tax returns, identifying the cottage as your principal residence, I think after 3 years you're clean. But that's that's something you need to check with your advisors.
What are the pros and cons of owning a cottage slash second property inside a corporation? What are the tax implications, benefits of doing so?
Well, corporations bring with it all sorts of unique tax opportunities. The corporation might be the source for the funding of the expenses as well. I would say you rarely see it in a corporate structure. We're putting a cottage in a corporate structure. And, you know, it's been shied away from pretty much on the planning side for many years because the actual incremental benefit isn't much better than putting it into a sort of trust arrangement. But of course, you can identify shareholders. You can make strict shareholders agreements within the structure of a corporation. I've seen a few family compounds in a not-for-profit corporate structure. Again, that's it brings with it, an ability to codify, contractually bind people a little stronger than the co-ownership agreements that I've talked about. Not a lot better. So, it's just, as I say, it's a bit of a unicorn tool for planning from my experience, because it doesn't give you that much an advantage, and it does create some real headaches.
Okay, this one's a little bit different. What do you see as the impact, if any, on the new CRA trust disclosure rules legislation with punitive damages for non-compliance?
Well, it's the real deal. I mean, next year, every trust in Canada is going to be cataloged. And what happened with many trusts, certainly in the 80s and 90s, with cottage properties, is that they put them into trusts as a tool, a planning tool that they paid very little attention to. And, if there's anything I always tell my clients that they have to remember is that if you do a document like a trust, it means something, and it's going to have consequences, legal consequences. And if you don't follow the rules as you administer it within that trust, you can leave yourself exposed to all sorts of problems. So when the new trust rules come in, people are going to be putting, because they have to, disclosing a trust for their cottage for which they may not have been managing it. They may not have been filing T3 returns. They may not have done the sorts of things that you need to have done administratively for many years. So there's going to be some catch-up work there, and you need to sit down with your accountant and find out if there's any exposure. Is there a voluntary disclosure that should be given because of whatever reasons, those sorts of things. So this triggering of opening up exposure to the whole beneficial interests of trusts in Canada is it's just going to regularize trust administration. And as I say, if you've got a cottage in it and you haven't paid attention to that, you're going to want to talk to your tax advisor to find out what, if any, rehabilitation work you need to do over the next year to meet up with the governance rules of trust law and CRA's taxing of trusts.
Okay, excellent. Well, we've got two more here, so we'll wrap up. This first one's a little technical, and the last one's a bit of a case study. I won't preface too much. So I have a U.S. condo with the following ownership: 20% me, parent, 40% to one daughter, 40% to another daughter. What are the consequences upon death?
Really depends on, there's so many factors there. We're looking at, depends where the daughters live. It also depends on the value of the condo. And it's not a bad idea, certainly with Florida properties, we're seeing more and more of the planning to be put the asset in, or a portion of the asset, as this question has done, in your name personally, so that the 40% interest can be isolated on your death, leaving the two remaining owners without any sort of particular filings requirements. So in that situation, your estate will be responsible for the capital gains on that. And then there'll be also U.S. tax that'll be hit. For example, a non-resident in Florida gets treated differently than a resident in Florida, those kinds of things. So those are the sorts of issues that'll come up, but it's really worth just sitting down with your tax advisor, and you're there in that situation. You'll want someone who's got some cross-border experience just to walk through the numbers so that it's ready to be paid or it's funded in some way, so that you don't put the two daughters in a situation where, and happens too often with recreational properties, where you force your children to have a fire sale because the funding isn't there to satisfy the taxing authority, wherever it is, whether it's in Ontario or in a different jurisdiction.
Okay, last one. Okay, it's a hypothetical but interesting question, according to this writer. A Canadian owns a cottage with a market value of $1 million and an ACB, or an adjusted cost base, of $400,000. The property is 9 acres. He has 2 children and decides to sever the property into 3 lots of 3 acres. He gifts 2 vacant lots to his 2 children and retains the remaining lot with the cottage on it. Question 1. Is the severance a disposition? And number 2, what is the tax implication of the severance to dad? Number 3, what is the ACB of the gifted lots to the kids? Okay, so this person wants a full planning session over a webinar, and I might encourage this person to reach out to Ian directly. And if you don't have his coordinates, just ask us and we'll direct you. But take your best stab on that last one, Ian.
Well, there's so many moving parts there. It's just very important that when you're looking at cottage properties and severance issues, of course, the main thing of there is that you want to keep top of mind is not just the tax, but the merger of title. So if you bought a property beside you, the Planning Act rules, and they just recently changed, you have to be very careful you haven't merged title with the property, so that therefore you have to go through the severance process. But presuming you have to go through the severance process, in and of itself, I just don't have the tax expertise, but my gut is, of course, there'll be lots of tax triggered in that scenario, except for the remaining stuff that's in your hands. But definitely, as you say, Dave, that's worth rolling your sleeves up with a tax advisor and a lawyer and working that scenario through. We can't forget that sometimes it's much better to pay for advisors than not, because if you're going to take steps like this, you want to make sure that you've thought through not just the tax consequences, but the legal impact of potentially merging title and things like that.
Okay, well, that's great, Ian. I think you've covered a lot of ground. I've just been along for the ride here and learned a bunch of things. I personally have used Ian's services in the past couple of years, and his staff and Ian have done a great job. So full endorsement here. Anybody who wants to reach out for any questions of their own personal situation, feel free to go directly to Ian's office and they'll take good care of you. Or if you can't locate them, then we'd be happy to arrange something for you. So thank you, Ian. That was great.
Thanks, Dave. Great to see you, and wonderful to be here. Thanks, everyone. Have a great summer.
Okay, and finally, our next webinar, we do them once a month, will be on Wednesday, August 20th, also starting at noon. The subject will be distributed shortly. It'll be most likely back to the financial markets because they are obviously in a lot of volatility of late, and we're seeing things actually starting to smooth out again right now. So we could be on the way back to a softer ride in the future. But anyways, I won't give too much away. We'll be doing a discussion more on the melt up that we think is just starting right now, as we believe the market bottomed out a while ago. So enjoy the rest of the summer, everybody. Be safe, and we'll talk to you later. Bye-bye now.